What happens if you forget to mention your child in your will? This is a situation that probably isn't going to happen too often, but it is entirely possible because there could be children who are born out of wedlock. There could be very dramatic situations where a child was in the womb before you wrote your will, etc., etc. So either way, I wanted to talk about children who are not included in the will. If you have any questions on this, you can go to my website, www.legionlawpllc.com, and you can schedule a free consultation over the phone with me directly. So, these children who are forgotten, let's talk about it because this is very important. A will should state all the children that are alive at the time of writing that will. Now, it's not a requirement. You don't have to have that, but it's a good idea because you can clarify these are the people I'm thinking of as I'm writing this will. Now, if you have three children, let's say I have three children, A, B, and C. A gets 50%, B gets 50%, and C is not mentioned whatsoever in that will. Texas says that if C is alive at the time of me writing that will, C gets nothing whatsoever. It may look like I forgot C, it may look like I accidentally didn't mention C, whatever, but at the end of the day, that is extremely important because C gets nothing under every circumstance under the sun. So, if you forget to mention a child, that's on you, and that child's not getting anything. But there is an asterisk to that. Texas says that if C is in the womb or not even born yet, before or after you've written your will. So in other words, I've signed my will and C is in the womb or C has not been born yet whatsoever. Then C can actually be entitled to a share of either that's equal to what everyone else is receiving or the share that C would have received if there was no will whatsoever. Because in Texas, there are default laws that say if you have no will, then we will give children XYZ. And that, it comes in all different shapes and sizes, but that is the default rule. Either that forgotten child who was born after the will receive something the similar size of all the other children, or they will receive something that they would have received if there was no will whatsoever. So we're going to do the will after we give that child their share that they would have received if there were no will. So it's kind of a weird rule. I'm not a huge fan of it myself, and it's kind of strange to explain it, but it is very important because a lot of people think if I don't mention all my children and if I don't, give them $1, and I made a video about this right now, or just recently, but if you forget your child, that is okay. If you did it on purpose, don't mention them in the will, you're okay. But if you have a child after you've signed the will, then these are when the rules would apply. That child receives the equal share or a share that they would have received under no will whatsoever. So either way, it's a convoluted way to say, try to remember your children in your will, just mention that you have them, and then forget them in the beneficiary section. Don't mention them to give them any assets if you're trying to disinherit them. So it's complicated. I'd love to be able to chat with you more. If you have any emails or questions about this, you can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can go to my website, www.legionlawpllc.com. You can schedule a free consultation over the phone directly onto my calendar on the Contact Us page. So thank you so much for watching and have a great day.